Next, I'm going to talk about the case of J&A, which is an interesting case in relation to forum conveniens. This was a successful application to stay divorce proceedings. Briefly, the facts of the case: the parties met in Dubai, married in England, and had a civil ceremony in Nigeria. They moved to Nigeria in 2009, then to England in 2011. The parties' children were born in England, and the husband returned to Nigeria in 2022. On the 8th of March 2022, without any prior notice to the wife, the husband filed for divorce in Nigeria. On the 14th of March 2022, without yet having knowledge of the husband's petition, the wife applied for divorce in England. The husband argued that the Nigerian court was the more appropriate and convenient court, which was disputed by the wife. The court found that the parties were more connected to England than to Nigeria. At the time of the petition, they had been habitually resident in England for 11 years. Importantly, the court did not place much weight at all on the fact that the husband's petition was first in time, or that the proceedings in Nigeria had advanced further, mainly because the husband had been seeking to prevent the wife from pursuing a legitimate claim in England. It was a significant factor that the wife couldn't easily travel to litigate in Nigeria, and that an English judge was better placed to undertake the assessment of providing for the wife and the children's needs, whereas the claims in Nigeria would be more limited. This case emphasizes that timing is, of course, a factor, but not always the central issue, and we might rethink how we approach these cases going forward.
One of MN versus AN. So this was a couple who were married in 2005. The husband was 10 years older than the wife and had been married before, and so he was insisting on a prenuptial agreement. He in fact was so insistent that they had to have a prenuptial agreement that he wouldn't agree to invitations to the wedding being sent out until an agreement was in place. This was, of course, because he had substantial pre-marriage assets, something like 32.5 million, whereas the wife had very little. They subsequently negotiated an agreement with the benefit of legal advice, and an agreement was signed 3 months before the marriage. That agreement provided for £500,000 for each year of the marriage for the wife, capped at a total of 12.5 million. And then after 8 years, or the birth of a child, in addition, she was to get 50% of the value of their London home, or 50% of the increase in the husband's assets over that period, capped at 42% of his net worth. There was also provision for maintenance and school fees. Then in 2019, the husband gave notice of an intention to divorce. At that point, enforcement of the prenuptial agreement would give the wife a £7 million Duxbury fund, plus 4.75 million for housing. Of course, the wife sought a greater amount and alleged that she'd been coercively controlled by the husband. Husband issues a show cause application as to why the wife should not be held to the terms of the prenuptial agreement. The decision in that case was, first of all, that there was no evidence of coercive control. And in fact, the judge was quite critical about conduct being raised in an issue that he said wasn't relevant. He said that the parties had been represented by first-class solicitors, and the outcome was well within the bracket of the cases that we usually see. He decided that the wife was not under undue pressure and there was full disclosure. Accordingly, the prenup was not unfair and she should be held to it.
Do you think it's fair to say that we're moving in the direction of the parties being held more strictly to nuptial agreements by judges?
Absolutely. I mean, I think is provided an agreement meets needs, and that's really, really important, and provided there are no other vitiating factors, then I think people really need to expect to be bound by these agreements. So as long as there is full disclosure, legal advice not necessarily, although that's helpful, then it doesn't really matter the circumstances in which they were negotiated or in which jurisdiction the agreement was finally signed. It's a really important document and people need to expect to be bound by them.